Logistics versus RLI Insurance. Mr. Morse.
Good morning, Your Honor. May it please the Court, Harry Morse on behalf of T Maritime. A marine underwriter choosing to write a policy has, in effect, three options for what to do with a notice of claims provision. The first is they just put an express provision in the policy. Thou shalt give notice within X time period. And if they do that, there is no doubt that this court and Louisiana courts will enforce that provision to the letter. In fact, this court has previously enforced a notice of claims provision for claims that the insured neither knew nor could have known about. The second choice that the insurer has is to apply the law of whatever state or whatever jurisdiction or whatever venue they deem appropriate. And there is no doubt that if they so do, this court will enforce that provision to the letter. The third choice is what RLI did here, is to be silent with regard to the choice of law provision. And when that happens, under Wilburn Boats, the law of the state where the policy was delivered will govern. The policy was delivered here in Louisiana. Everything happened here in Louisiana. So when RLI wrote an insurance policy, and they delivered it in Louisiana, they opted into a number of decades of this court's and Louisiana's jurisprudence with regard to what prompt notice of claims means. And what prompt notice of claims means under this court's jurisprudence is not precisely, but roughly, that if the insurer has the opportunity to participate fully in the litigation, if it has the opportunity to undertake factual discovery, if it has the opportunity to hire experts, to hire its own counsel, if it has the opportunity to settle the claim before trial, then there is no prejudice.
Are you describing that as the limit of what's considered prejudice for prompt notice purposes? And if so, what case states that limit?
Your Honor, this court's decision in Elevating Boats approves the district court's opinion, and there the district court found there was, in fact, prejudice. And it found three reasons. The first is that the insurer could not make prompt investigation of the claim, which, in fairness, I think that applies here. The second is that the insurer could not appoint its own counsel to represent its interest, and that very clearly does not apply here. And then the third is that the insurer could not settle the case for less than the judgment actually awarded, and that very clearly does not apply here. And what this court said in affirming that judgment of prejudice is the insured took a calculated risk to keep a claim off its loss run. And then 2 weeks before trial, the insured gave notice to its underwriter, which is, colloquially, dirty pool. And that's just not what we have here. I think the other goalpost here is Gulf Island 4, where the insured was represented the entire time for a hull claim and went through the entire analysis. The insured was represented thoroughly and completely. And because there was overlap of interest between the insurer and the insured, there was, in fact, no prejudice.
Okay. In your brief, you say that your client had a very good reason to think the claim was really worth nothing and therefore ignored it.
That's right.
Okay. Given that the claim has now settled for $200,000, it was not worth nothing and should not have been ignored. How can we not say that RLI has not been prejudiced under the actual facts of this case?
Your Honor, a number of responses, but the first and most important is this. The claim settled for $200,000 because the vessel was arrested. Mm-hmm. The vessel arrest drove the settlement. That is a litigation tactic, and frankly, an incredibly successful one, by a litigation opponent. Now,
that was completely, that was allowed.
Yeah, it is, absolutely. It is completely allowed. But the fact is that is something that could happen in any claim, and in all likelihood would have happened here regardless of notice to the underwriter. And the reason we know that...
If the claim has value.
Well,
the claim has to have value,
or
else the arrested vessel and then the sale, wouldn't, if it turned out that it didn't have value, then they posted a bond and done all that.
The testimony in the record from Mr. Manuel is that the damage that actually occurred here was a couple sacks of crickweed that had been ripped open and got wet. That was the embankment, and the tow alighted with that. The reasonable value of that is fractional. The underwriter sent a reservation of rights, not relying on late notice of claims, but relying on the automatic acquisition clause. And so if you take this back to day one, and if A&T, as they certainly should have, gives notice to RLI on day one, but then you take it from there, and the insurer investigates the claim, and then the Champagnes arrest the vessel, which is absolutely their right to do, you're in the same exact circumstance. And the reason for that is, first of all, an insurer has no obligation to post a letter of undertaking. Second, RLI, in all likelihood, would have relied on the very same provision of the policy and wouldn't have posted a letter of undertaking. And so the settlement still would have been driven by the arrest of the vessel, and that's what would have made the claim much more expensive.
Do you have any case where the insured gave no notice for 1 year?
Your Honor, in Gulf Island 4, the insurer gave no notice for 4 years. And at elevating boats, it was a number of years before the insurer gave notice. And in both of those cases, that was not dispositive. In Bollinger, which is a district court case, the insurer didn't give notice for, I believe it was 5 or 6 years before this occurred, before the litigation was filed. And in that case, the district court collected cases from Louisiana and said this is not enough to show prejudice. I haven't found a case, and my colleague has not found a case, in which an insurer who has fully participated in the litigation has been able to rely under Louisiana law under...
Well, that was the question I asked you at the beginning.
That's right. I haven't found the case, Judge. To my knowledge, it doesn't exist. And if this case so finds, and except for the district court, then that would be the first case to find that an insurer that participates fully in the litigation.
Of course, what I don't understand, it is a fact issue, right?
I think that's exactly right, Your Honor. There's a fact issue.
Well, so here, the owner of the vessel had offered $3,500 to the Champagne's predecessor.
That's right.
And, whether that was accepted or not is unclear, but money didn't change hands. So then the vessel just goes on its merry way, acting as if nothing had happened, because God forbid they should notify the insurance company. And then the new landowner comes in and says, well, doggone it, we're going to make something happen here, right?
That's exactly right.
So the vessel was gambling that this would go away, and they lost big time, and I don't understand why that isn't prejudice as a fact issue.
Your Honor, I think it's a fact issue as to prejudice, and the district court here granted summary judgment. Thank you.
Okay.
Good morning. Corey Parenton on behalf of Alexis Marine. May it please the court. Judge Jones, I think your question to Mr. Morse was an excellent segue for Alexis Marine's position. It's different from A&T Marine. It was the owner of the vessel that was bareboat chartered, but it is also an additional assured under the RLI policy. So what we have to look at here is how does the notice of loss provision apply to them? If we read the notice of loss provision as written in the policy, it requires prompt notice of a claim for which RLI may become liable. Not a claim that arises, not a claim as it occurs, but a claim for which RLI becomes liable. Under a P&I policy, there's a deductible. Here, $10,000.
Is it clear when they were notified? Because Manuel's deposition seems to say it was either the week of the elision or at the end of August. Which was it?
Alexis Marine, I'm sorry, Judge, is that your question? When was Alexis Marine notified?
Yes. Was Alexis Marine notified the week of the elision or the end of August? Which was it?
I don't believe the
Or
record.
do we not know?
We don't know. The record doesn't have it. But in either event, and with respect to the way that the notice of loss claim is written, I'm not sure it exactly matters. And I think what does matter,
Well,
when
when
Alexis
they-
Marine was brought into this litigation, when the Uncle John was arrested, which is Alexis Marine's true first notice that there's a claim that may be covered under this policy.
Well, once it knows about the elision, though, why wasn't Alexis Marine's own delay in notifying RLI at either the week of the elision or the end of August not independent grounds for prejudice?
I think if we look at the practicalities of the situation, Judge Elrod, and I think that's a very important consideration here is the practicalities. Number one, there's a claim that Mr. Manuel says to Mr. Alexis that I bumped into the embankment. It looks like a couple broken bags of Quikrete, I'll take care of it out of pocket, no worries. So at that point in time, perhaps a $3,500 claim, it doesn't arise past a $10,000 deductible level. It's not something that Alexis Marine is on the hook for because Alexis Marine had no fault here. Under the policy, it is simply an additional assured who lent its vessel to Mr. Manuel, to A&T Marine, to operate as necessary. So Alexis Marine has done nothing wrong. It does not need to take upon itself Mr. Manuel's own duty to alert his carrier if that's the appropriate situation. Even in the August email, and I've looked in the record, and we don't have the engineer's report that's allegedly discussed in that email, we still have no indication that this claim arose above $10,000. All we have is that...
Doesn't that put you on notice to go gather information from the ship?
Perhaps, and quite frankly, Mr. Manuel should have done that. Mr. Manuel should have done that. I don't think it's improper for Mr. Alexis and Alexis Marine to rely on the charterer to adhere to their obligations, to defend and indemnify Alexis Marine for any claims that arise.
Can you help me understand why the cross liabilities clause applies here? Because that applies when one assured brings a claim against another assured, but there's no claim between Alexis and AT&T Maritime. So why did the cross liabilities clause apply?
There is a claim still pending between the two for contractual defense and indemnity, but I think the cross liabilities application perhaps is overstated in the brief. But I believe if we look at Norfolk Shipbuilding, this court's opinion and what it looks to, there's a third-party claim, which we have here by the Champaigns against Alexis Marine. There's a claim by one assured against the other, which in the third-party demand by Alexis Marine against A&T Maritime, it brought its claim against A&T Maritime. But the most important aspect of the cross liabilities clause, and I think more so the spirit of that clause than the actual rigid application of it applies here, is that the two must be treated as separate assureds, as if both bought that policy individually. And if we look to that, and we look to the notice of loss requirement, which says at the time this policy may become liable, which is when the loss exceeds $10,000, that becomes the point in which the Uncle John is arrested. Largely unbeknownst to Alexis Marine, in its own operations, now has a vessel under arrest by the United States Marshals. And to Alexis Marine's knowledge, and I tried to do the math and I believe it's correct, we have a claim that goes from $3,500 potentially settled for over 57 times that original amount. That doesn't just happen overnight without information. There's no information conveyed, and there's none in the record that shows Alexis Marine should have at any time anticipated that this claim would grow by 57 times. Not to mention the sought amount in the pleadings when this matter was up for hearing on a release of the vessel.
Okay, so you're not relying specifically on the cross liabilities clause. Are you relying specifically on the privilege to name additional assureds clause?
Your Honor, I think that's actually not even in dispute that Alexis Marine is an additional insured, and indeed they can be named as an additional insured, and the clause extends not only to a named insured, but the owner of a vessel insured.
Okay, assuming arguendo that the cross liabilities clause doesn't apply, which you're pretty much, you're not really arguing. Why should we hold that the privilege to name additional assureds clause applies as if each assured had a separate policy? In other words, why would actual prejudice caused by one of the assureds not void coverage for the additional assureds? The cross liabilities clause includes the as if separate policies had been issued language. The privilege to name additional assureds clause does not include such language. So you've got a policy language issue, I think, with this approach.
Sure. And the way I can best explain it is if we look at this court's history of cases, I believe Randall versus Chevron might be one, Fontenot might be another. We deal with it a lot of times in maritime law with the as-owner clause. And we understand that under policies, different additional insureds have different roles. Here, Alexis Marine is protected in its role as owner of the Uncle John, but it's not the operator. It's not doing the same things that T Maritime is doing. It just gets that additional protection because it is its property that is lending to another for its use. It has no fault in this case. There's no allegation that Alexis Marine did anything wrong, but it still is entitled to protection as the owner of the asset that's lent. So in that respect, there are separate risks insured. And so therefore, there's essentially a separate policy issue. We're going to protect you in the event something goes wrong.
But it doesn't have that language, which was in the other section. So when the policy was written, they knew how to put that language in there and specifically put it in the other time it could come up, but didn't put it here. Isn't that, can we just ignore that?
Our jurisprudence tells us that we can't read into the policy what's not there. I understand that argument, and I understand where you're going, Judge Elrod. But at the end of the day, Alexis Marine is not a policy holder. They're an insured. They don't have the terms and conditions available to them. They're not presumed to know what that policy says. They're only allowed under their contract, under their bareboat charter, to understand that they have been adequately insured by A&T Marine. They can get a certificate of that insurance, and at the end of the day, when something like this arises, they can make a claim for insurance under that policy. But I think their role and their responsibilities in this case are very distinct from A&T Maritime, and they must be viewed as such with respect to the notice of loss. Appreciate your time.
All right, Mr. Sharpe.
May it please the court. David Sharpe for RLI Insurance. The first thing I'd like to address is the question I think that was kind of implied, Judge Jones, in one of your first questions. When does the prejudice clock start to run? And really, A&T consistently argues that the prejudice has to be post-lawsuit. And I don't think that that's what the case law says. On the subject of prejudicial notice, our best case is also elevating boats. That was factually different in terms of when the notice occurred and the lifespan of the case. But this court, pointed out the kinds of prejudice that it thought was important, saying that the late notice had denied the underwriters the basic opportunity to investigate the facts surrounding the accident, the opportunity to interview witnesses while their memories were fresh, to examine the scene of the accident, and so forth. So this case does not, fortunately, involve bodily injury. It was property damage. But those things, the ability to interview witnesses while their memories are fresh, those don't happen post-litigation. Those need to happen as soon as possible, or as the way the policy is worded, as soon as practicable. And that notice just wasn't given, and that's when the prejudice happens. Likewise, the email, or the letter rather, from Mrs. Dampier in the record, where she kind of beseeches Mr. Manuel to engage with her since the situation is getting worse. That again is a really strong indicia of prejudice because the situation evidently was getting worse. Maybe it was just a tiny split in a bag of Quikrete when Mr. Manuel saw it, but 3 months later, after the March accident, 5 months later almost in August, she says it's worse. That's when you bring in the underwriter. You say, I don't think it's a bad claim, but I'd rather be safe than sorry. But the underwriter didn't have that opportunity to then get its own investigators out there, its own marine surveyor. So that's the prejudice that occurred. I'd also like to talk about the cross liabilities and the Alexis notice issue. First of all, in the reply brief, Alexis says that RLI has waived its ability to argue that Alexis itself had to give notice at its reply brief at 7 and 8, asserting that this point was absent from the lower court briefs, and I just want to show that that's not the case. In fact, in RLI's answer, which begins in the record at 266, RLA brought that up in affirmative defenses and affirmatively in its counterclaim, specifically that both A&T and Alexis had separately and breached the warranty of late notice. It also was briefed in the first motion for summary judgment that Judge Zaney granted on the coverage issue. So I think that argument has certainly been preserved, and I think that the argument that Alexis makes to say, well, we had our own separate policy, whether it's under the now abandoned cross liabilities theory or the privilege to name additional insureds theory, I think that kind of cuts against them. If they have their own policy, they've got their own duty to give notice. So I don't think that gets them to a place where the named insured can prejudice the insurer all at once, and the additional insured can sit back and gets the benefit of a complete P&I policy just without any notice provision whatsoever.
Do you have any case law that suggests we shouldn't interpret the policy to give Alexis Marine its own coverage independent of A&T's failure to give the prompt notice?
No, there's nothing that we've found that's not in the brief, and we rely on the wording of the policy, and we don't think this is one of those situations, even if Louisiana law is brought in on this marine insurance policy, where there's an ambiguity that needs to go to the benefit of the policyholder. Another thing about the prejudice,
Are you still answering the question?
I beg your pardon?
Are you still answering Judge Elrod's question? I have one for you. I don't want to interrupt.
Yes, sir.
Are you through answering her question?
I'm all through, I think. Thank you.
Cover just the time lapse between time of the elision and when Alexis Marine was advised about the accident, since it was a bareboat charter.
And your question is how much time was that?
Yes, sir. The timeline.
Yeah. So counsel was correct that the record is a little bit unclear. There's a page from the deposition that was not included that might have shed some light on that, but it's not in the record. And so it's two possibilities. It's either within several weeks of the original elision, which would move it back towards March, maybe April, or it's several weeks of the letter that Mrs. Dampier sent in August. And so this is, the answer was, when did you talk to the Alexises? Probably within the same week, and we don't know which week that was. This is ROA 1298. Unfortunately, the next page where there might have been some light shed on that was not submitted as part of the summary judgment record. But either way, Judge Barksdale, they knew by August, September, perhaps maybe mid-September, And the property did not change hands until January, according to Mrs. Dampier, and then it wasn't long before the Champagnes, the new property owners, took the steps that they did. One last word on the steps taken in the litigation, the arrest of the vessel. Again, without a doubt, that ran up the cost of this litigation. But had the insurance company been involved earlier and had been notified, it would have been the insurance company's risk that the case perhaps didn't settle if the insurance company didn't offer Mrs. Dampier enough money, or perhaps even if the property had already changed hands. In the new plaintiffs, the Champagnes, had said, pay us so much or we're going to arrest the vessel. Even then, the insurance company could have put up security to either avert or release an arrested vessel, and that didn't happen. Of course, now that's part of the damages that are being claimed by both policy holders, but it all could have been avoided if RLI had been notified sooner. So just to sum up, we ask the court to affirm on the summary judgment record that Judge Zaney held was sufficient and tax the costs to the appellants. Without further questions, I'll be seated. Thank you, Your Honors.
Rebuttal, Mr. Morse.
Your Honor, I'll be brief. I heard.
No,
Sir.
don't count this against his time, but I don't believe I've ever heard a rebuttal argument where the lawyer doesn't begin with, I'll be brief. And of course you're going to be brief. You only got 4 minutes.
Sir.
But anyway, go ahead.
That's eminently fair point, Your Honor. I heard my colleague say perhaps a number of times. I myself said perhaps a number of times. The Eastern District in Bollinger said that prejudice has only been found when the insurer is not notified until the eve of trial on summary judgment. And that's what happened here. Summary judgment was granted, but the insurer was notified. I'm not saying the district court can't find prejudice. I am saying that with this number of perhapses, doing it on summary judgment is significantly premature. And I go back to what I started with. In the event of a condition precedent, the insurer need not show causation. We don't have that here. And I think that what that does is an insurance contract is nothing more than a specific species of contract. And so nobody here is saying that A&T did the right thing. But it is not asking too much to have RLI show that that is the cause of the damages here. And it's well within the right to prove that.
Why would it not be the cause?
Pardon?
I say, what's your best argument to the jury as to why that's not the cause?
Because RLI mistakenly relied on the automatic acquisition clause the entire time. And I think that the testimony at trial would show that they would have done that same thing and would be in exactly the same position because they would have relied on the same argument they made at the very outset on the automatic acquisition clause, and they would not therefore have posted a letter of undertaking or a bond to free the vessel, and therefore the vessel arrest would have driven the value of the settlement throughout.
Are you making do you have evidence on that?
They don't have evidence because on summary judgment, the record is incomplete.
Well, apparently there were depositions.
There were depositions, Your Honor, and what we have here is we have Mr. Manuel who testified under oath that he thought that this was effectively going to go away for $3,500. And then we have an affidavit from Ms. Dampier who says, under no circumstances would I have taken $3,500.
The court did not use that affidavit and specifically excluded that affidavit because it was filed after the summary judgment, wasn't it?
That's true, Your Honor, but it was...
You can't rely on that as the counter evidence. There was no counter evidence before the district court about the $3,500.
The district court asked for briefing on the legal question and then asked for additional briefing on what the remedy should be because the district court found prejudice. And so though the district court didn't rely on it, that affidavit was absolutely tender while discovery was ongoing.
But the court said that it was not going to consider that And I don't believe you've appealed that evidentiary finding. Have you specifically appealed that?
That has not been an issue of error appointed, that was noted in my brief, so you're absolutely right about that, Your Honor. Nonetheless, there are significant fact questions with regard to what would happen in a trial on the merits. And I don't know what the answer is, and I don't think the district court does either.
Well, you had to bring forth those.
You're
Explain that there was the fact questions, not just say in the air that there are.
Well, I think, Your Honor, the fact that RLI first denied coverage on the basis of the automatic acquisition clause and not referencing late notice is a significant fact question that merits reversal. Unless there are any questions, thank you very much for your time.
Okay, thank you, sir. Court will be in recess until 9 o'clock tomorrow morning.